Yo, yo, yo. It's so sad that it's come to this. It's so sad that here I am having to make a third video now for my boy V. V, I love you. I love you, but you went smug on me. You acted smug on me, like you knew more. You pretended you knew more than a random person on the internet. No, never pretend you know more than somebody on the internet. You know more than most of your chat, sure, but do you know more than 100% of your chat? No. You should stay in your lane, medical boy. Alright, let's get into this. Hey there everybody, I'm making a third video now talking about doxing and free speech. What is it? Is it legal free speech? Or is it the most criminal type of speech there is, right next to fraud and threats of violence? Let's figure out here. I have some sources. Let's just slide this. Where's my cropped camera? Actually, I like the cropped better. So I have the Rodriguez Law Group from Los Angeles Criminal Defense Attorneys. Hopefully I'm not doxing their public business right now, but toll free. Fact or fiction, doxing someone can get you arrested. May 14th, 2022. We'll go over the actual statute. It's right here. I have the statute pulled up. But we're going to go see what these lawyers' opinions are, because the statute doesn't have everything. Many people are not familiar with the word doxing. However, they are familiar with cyber stalking. Stalking may involve doxing. Doxing is the use of internet to gather personal identifiable information, PII. Some examples of PII include, but are not limited to, full name, social security number, contact information such as street address, telephone numbers, email addresses, etc., workplace details, financial information, and family members. The party publishes the information online for malicious purposes. Okay, so I notice in this little list here, it doesn't say pictures of houses that don't mention a street address. No, but it says it's not limited to. But it's, again, this would have to be figured out in court. Is a house an identifying information? I would argue no. Because that takes a lot of work to try to figure out which house. I mean, people are saying, have you heard about he will not divide us in 4chan? The power of 4chan autism is amazing. Yes, I admit 4chan autism is a force of nature that needs to be harnessed for good. But when you consider how easy it was to find it if you just Google Jack Films LLC, there is no need for that level of autism. But I digress here. Let's go read the case law, the statute. I mean, not the case law. We'll go over some case law too, because V, my boy V, he's like, oh, don't you know, radically moderate, that not all speech is protected? Threats aren't protected. We'll go over that. We'll figure out what exactly is protected free speech. Maybe the bounds of free speech are a little bit more broad than a Romanian doctor knows. I'm sorry, V. Stay in your lane. You're good on SJW stuff, but now you're becoming the SJW you were fighting against 10 years ago. Literally. Here is the penal code. 653.2. This is the doxing law. Every person with the intent to place another person in reasonable fear for his or her safety. So you have to have intent. And this is the actor has to have subjective intent. We'll go over Supreme Court case law because some people don't think I do the research around here. So she has to have the subjective intent that she is placing him in fear for his life. No one has proven that yet. That she thought that she knew she was going to cause him harm or try to cause him harm by posting a picture of his house. Very important part of the statute. If any one of these parts is missing, you don't have the law being broken, and it's not doxing then, according to this law. Maybe in a more colloquial sense you want to say, but we're talking about legalese here, because V said twice that she broke the law. She broke the California law. He defamed her by saying she broke a law when actually she didn't, V. She didn't. Maybe you should do your research some more. For the safety, okay. With the intent of placing another person in reasonable fear of his or her safety or the safety of the person's immediate family by means of electronic communication without consent of the other person and with the purpose of imminently causing that person unwanted physical contact, injury, or harassment by a third party. So she has to, with the purpose of imminently causing that person unwanted physical contact or injury or harassment. Electronically distributed, so this is just talking about how they're covering all forms of sharing it online. Hyperlinks, so she posted it on her Instagram. Makes available for downloading personal identifiable information. So this is what we have to figure out. Is a picture of a house without a street address personal identifiable information? You don't even know what state she's in. You don't even know. So, including and not limited to a digital image of the person, an electronic message of harassing nature about another person. So, is a picture of someone's house harassing nature? I would argue no. That's the Streisand law. Maybe V is not familiar with the Barbra Streisand effect, but Barbra Streisand is a famous, or was a famous, I don't know, actor, singer, I don't know, Hollywood type person. And people were taking pictures of her beachfront house, and she was like, I don't want that. I want them. That's illegal. You can't post pictures of my house online. It's harassment or whatever. And people are like, you stupid idiot. You can't. That's free speech. And so people started purposely posting pictures of her house online as a gotcha, because she was trying to sue people and get websites taken down for hosting her, for hosting legal speech of someone's house. I'm sorry, posting pictures of someone's house is legal speech. Let's continue. Of harassing nature about another person, which would likely to incite or produce an unlawful action. So, is posting someone's picture of someone's house likely to produce an unlawful action? No, it's not. It's not, sorry. Is guilty of a misdemeanor up to 1 year, blah, 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 blah. So, harassment is the knowing and willful course of conduct directed at a specific person that a reasonable person would consider seriously alarming, seriously annoying, seriously tormenting, or seriously terrorizing the person and serves no legitimate purpose. So, now this is what this, does posting a picture of someone's house online serve no legitimate purpose? We'll have to figure out what happened to Barbra Streisand there. Of a harassing nature means of a nature that a reasonable person would be considered seriously alarming, seriously annoying, or seriously tormenting, seriously terrorizing a person, and would have no legitimate purpose. Let's see what else happens here. How about some case law? Because my boy V doesn't think we do case law around here. I'll increase the size of this. Can I just do that? Oh, that's nice. RAV versus City of St. Paul. This case dealt with St. Paul bias-motivated crime ordinance that prohibited display of symbols that aroused anger, alarm, or resentment on the basis of race, color of creed, religion, or gender. The court ruled that the ordinance was unconstitutional because it specifically targeted speech based on content which violates the First Amendment. Sider versus Phelps. This case involved the Westboro Baptist Church protest at soldiers' funerals. The court held that the First Amendment protected the church members' speech, even though it was viewed as highly offensive and hurtful. This decision emphasized the importance of protecting even speech that is considered distasteful and highly offensive. And lastly, Brandenburg versus Ohio. This is where V doesn't understand what a true threat is. Brandenburg versus Ohio. The Supreme Court established in this case that speech advocating for the use of force or law violation is protected. You can say, let's all break the law. That's protected free speech in the United States. Unless it is directed to inciting or produce imminent lawless action and is likely to incite and produce such action. So you have to actually say, let's all break the law right now by doing this action right there. Imminent. Now. Not 5 minutes from now. Now. Imminent. So, when Trump said, let's all march down to the Capitol, the fact that there's like a 5-minute walk from them, the speech place to the Capitol, means it's no longer imminent. So Trump can't be charged with inciting violence. It's really kind of crazy that they're trying to, say Trump incited violence. But let's continue. I have another case that my boy V here may hate the bounds of free speech here. Because, okay, look at this. I'm doing my research here. On what page are we on here? I have it highlighted. I was reading this law review. What's the name of this site? The Doxing Dilemma, seeking a remedy for the malicious publication of personal information. So this is actually, it's a law review. It's when like law students kind of write their opinion or give like a summary on a bunch of cases and the standing of a law. And like, so here they're talking about doxing. Is it legal? Is it not? What cases support it? What don't? And these a lot of these legal types are very left wing. So they're actually this is published in 2017. They're talking about Brianna Wu and Gamergate. It's kind of interesting. They're going over it, and of course they're talking about doxing via punching down is bad. So when you go after Brianna Wu, even though she's like a game journalist that you think she's a position of power, no, she's a woman. You're doxing down. That's bad. But doxing, like political opponents, doxing up is good according to these people. So here they give them information. Here's what they consider to be doxing: home addresses, social security numbers, employers' contact information, families' contact information, photos of children, the schools they attend. Notice how they don't say photos of houses on here. Yeah, so I guess not according to these people's definition of doxing. It's as the sniper wolf is clear. So doxing is a tool. The intent behind it determines the proper approach for analyzing it. Punching down, doxing for the lulz, or worse. So this is the thing. We don't know her intent for posting the guy's house. That's ultimately the ultimate thing. I see literally talk about Gamergate in this law review article. It's pretty cool. But let's go down. Oh, I missed my place. Crap. There was a case they referenced here. The First Amendment. The true threat exception. The First Amendment is not an absolute bar for regulating speech. Certain categories of expression are either not within areas of Constitution protected speech, or the protection of free speech does not extend to them. The question is whether certain types of harmless speech, such as doxing, can be prescribed running afoul of the First Amendment. In Cohen versus California, the Supreme Court held that ability to regulate speech depends on a showing that a substantial privacy interests are being invaded in an essentially intolerable manner. Which, so people talk about your right to privacy. Your right to privacy, that's kind of a legal fiction. Which one of your amendments says you have a right to privacy? You have a right to undo searches and seizures by the government. That's not really a right to privacy. Anyways, let's see here. The First Amendment does not protect speech or writing that has an integral that is an integral part of criminal conduct. The exception most relevant to this is notes effort to find a remedy for doxing is a true threat exception. True threat is not constantly protected speech. They encompass statements in which a speaker means to communicate a serious expression of an intent to commit an unlawful violence against a particular person or group of individuals. A true threat exception is exemplified in the idea that while advocating for violence, it is considered protected speech. Threatening a particular individual with violence is not. However, statements that amount to political hyperbole do not constitute true threats. Actual intent to carry out a threat is not required for communication to be constituted as a true threat. That's 110. They're citing REA versus right there. That's the Supreme Court case I brought up. Rather, a prohibition on true threats protects individuals from fear of violence and fear of disruption by that fear engenders. In addition to protecting people from the possibility that the threatened violence will occur, true threats can also include intimidation when a speaker directs that threat to a person or group of persons with the intent of placing that victim in a fear of bodily harm or death. So there's got to be intent there. Importantly, a true threat exception extends to true threats that are posted on websites, communications, or over email. Let's keep going. I'm almost done. I'm almost there. In addition to deciding whether speech constitutes a true threat and is thus unprotected by the First Amendment, courts consider the totality of circumstances and whether a threat is conditional and a reaction of the listeners. For example, in Ilanis v. United States, the Supreme Court held that the sole reliance on the objective intent standard in assessing true threat would not suffice. Okay, so we're gonna try to go here. Just saying objectively posting a picture of someone's house is not enough to figure out if it's a true threat. Because here's the facts: Anthony Ilanis was arrested on December 8th, 2010. In charge of 5 counts of violating federal anti-threat statutes. He was specifically charged with threatening his ex-wife, co-workers, and kindergarten class, in the local police, and an FBI agent. Ilanis had posted statements on Facebook that appeared to threaten his ex-wife and people in his life. Prior to the postings, his wife and family had left him, and he had lost his job at an amusement park. Shortly after this chain of events, Ilanis posted several statements on Facebook that were interpreted as threats. At his trial, Ilanis asked the court to dismiss the charges, stating that his Facebook comments were not true threats. He argued that he was an aspiring rap artist, and that his comments were merely a form of artistic expression and therefore a therapeutic release to help him deal with the events of his life. In an apparent attempt to underscore his comments should not be taken seriously, he posted links to YouTube videos that he parodied and noted that popular rap artists often use similar language in his lyrics. For several of his comments, he posted a disclaimer stating, "This is not a threat." Despite the fact that his ex-wife, an FBI agent. Oh God, his wife was an FBI agent. God, that's awful. And others viewing his comments might have perceived his statements as threats. Ilanis argued that he could not be convicted of making a threat because he did not intend to threaten anyone with his postings. In other words, he claimed that he did not mean what he said in a literal sense. In legal terms, he said he did not have the subjective intent to threaten anyone. The trial court denied his motions to dismiss the case. The court held that the proper legal test for determining whether someone made a threat is an objective one, whether a reasonable person hearing the comment would perceive it to be a threat. Ilanis was convicted of 4 or 5 counts. He was sentenced to 44 months in prison and 3 years of supervised release. He appealed to the United States Supreme Court for the third and was affirmed on his conviction. The United States Supreme Court granted certiorari, agreed to hear his case. An oral argument was heard on Monday, December 1st, 2014. Decision on June 15th. So let's actually hear the... do I do the oral argument, or do I just do like the opinion of the courts? Facts of the case. Question: does a conviction of a threatening another person require proof of the defendant's subjective intent to threaten? Yes, it does. The Supreme Court held that the prosecution needs to show that Alanis intended the post to be threats. Therefore, there was a subjective intent to threaten. Man. It's got to really suck for all these guys saying that Sniper Wolf threatened this guy when you got to have the intent to threaten. Did she have the intent to threaten? I hope she didn't admit to that. Because right now, we don't know what her intents were. I'm sorry if this is uncomfortable for you. What did Clarence Thomas say? He said, a concurring opinion. An objective reasonable person standard does not go far enough to separate innocent, accidental conduct from purposeful wrong acts. The court held that, in this case, an objective standard would risk punishing an innocent actor because the crucial element that makes this criminal behavior is the threat, not merely the posting. I want to hear the oral arguments. I'm just going to bask in them and just laugh at my favorite Romanian doctors who don't know free speech laws. Opinion announcement. They do opinion announcements?
I have the opinion of the court this morning in case number 13983, Alanis versus United States. Section 875.
I usually hear the oral arguments. I've never heard an announcement before. This is interesting.
Of the United States Criminal Code makes it a crime to transmit in interstate commerce, quote, any communication containing a threat to injure another person. Petitioner Anthony Alanis was tried under that provision for posting threats on Facebook. Alanis posted gruesome and violent narratives, many in the form of what he considered to be rap lyrics. But his subject matter involved real people. He wrote about killing his soon-to-be ex-wife, who had recently left with their 2 children.
Oh, boy.
And killing co-workers,
oh, boy.
class of kindergartners, and particular identified law enforcement officers.
Oh, boy.
Alanis said his violent rap lyrics were an artistic way to vent frustration, and that he didn't actually mean to threaten anyone. He said, for example, that he was just emulating the rapper Eminem, whose lyrics included fantasies about killing his wife. Alanis also stressed that he included disclaimers with some of his posts, saying he was just exercising his First Amendment rights. The judge at Alanis's trial said it didn't matter what Alanis thought. All that mattered, the judge told the jury, was whether Alanis posted the material, there was no dispute about that, and whether a reasonable person would consider the material to contain threats. The jury convicted Alanis, and he was sentenced to over 3 years in prison. His conviction was upheld on appeal, and we granted review. Section 875C doesn't say anything about what a defendant thinks. It simply prohibits transmitting something that contains a threat. If you want to avoid prosecution under that provision, you should be careful about what you transmit. That is the government's argument. But there is a general principle.
That's an anti-free speech argument, though, because in America, the purpose of our First Amendment right and the purpose of free speech is to allow people to make mistakes. By exercising free speech, you're kind of thinking out loud, and when you're thinking, you may think something wrong. You may make a mistake. But when you make a mistake, then you can be corrected by people. But if you are never allowed to speak what you think could be a mistake, then you're never allowed to be corrected on that. So whatever, I'm digressing.
In our system of federal criminal law, that serious criminal punishment should only be imposed for conscious wrongdoing. The leading modern case explaining that principle is a 1952 decision from this court, Morissette versus United States. Morissette found shell casings on an old, defunct World War II bombing range. He thought they were abandoned, and so he collected them and sold them as scrap metal. But the government did not consider them abandoned, a fact Morissette learned the hard way when he was convicted of illegally making use of government property. But we reversed his conviction. The statute under which Morissette was convicted did not expressly require that he intend to take property the government still claimed, but we read such a requirement into the statute. We held that Morissette must have a culpable state of mind before being subjected to serious criminal penalties. In other words, if Morissette was unaware that he was stealing, he should not be prosecuted as a thief. Justice Robert Jackson wrote the opinion for the court. In characteristically eloquent terms, he said that the principle, quote, that an injury can amount to a crime only when inflicted by intention is no provincial or transient notion. It is as universal and persistent in mature systems of law as belief in freedom of the human will and a consequent ability and duty of the normal individual to choose between good and evil. This case involves that same principle. Ilanis says he's not choosing evil over good if he communicates something that he does not think is a threat. So he says the jury should have been required to find that he intended to threaten someone before convicting him. We agree, at least to the extent of holding that the lower courts were wrong to uphold Ilanis's conviction. That conviction was based solely on whether a reasonable person would regard Ilanis's communications as threats, regardless of what Ilanis thought. That is a negligence standard, which is enough in most civil cases to support liability. But as a general matter, mere negligence is not considered enough to support a criminal conviction. This is not a case of ignorance of the law being an excuse. It does not matter whether Ilanis knew it was against the law to send threats. The question is whether he meant to send threats in the first place. The jury was not required to find that he did, and so Ilanis's conviction cannot stand. Justice Alito has filed an opinion concurring in part and dissenting in part. Justice Thomas has filed a dissenting opinion.
Man, that pesky free speech thing just keeps on getting in the way of taking down sexy YouTubers. Can we speed these up?
We'll hear argument next this morning in case 13983.
A little crunchy.
Ilanis, United States. Mr. Elwood.
Mr. Chief Justice, and
may it please the court.
The First Amendment permits restrictions on the content of speech for a few well-defined and narrowly limited classes of communication, clearly supported by history and tradition, including what this Court has called true threats. The government has failed to justify including...
I'm not sure that the Court did either the law or the English language much of a good service when it said true threat. It can mean so many things. It could mean that you really intend to carry it out. A, you really intend to intimidate the person, or that no one could possibly believe it. So I don't.
That's true. And
we can't fault you for citing what the Supreme Court has said, but it's a most unhelpful phrase.
And it also doesn't help that it was announced in a per curiam decision that didn't have the benefit of merits briefing or argument. But if you look at the tradition, threatening speech was not punishable at common law, and until the late 20th century, American threat statutes required or were interpreted to require...
Okay, guys, listen. We're talking about threatening speech. I'm going to go ahead and say that here's doxing and here's threatening speech. That the bar threatening speech is more serious than doxing. And so if the standards for doxing are really are like keep getting lower, the Supreme Court lowers them, the standards for threatening, like the real whatever, doxing has to be lower than that. The same, if not lower. Does that make any sense? I don't think that made sense. If you want to convict someone for threatening, you need some evidence. Oh God. I'm trying to explain the law now. No, I look like an idiot. Let's let these judges talk.
Proof of a subjective intent to place the listener in fear. And because of that, there's just...
That was an assault at common law, wasn't it? If you threaten somebody with violence and don't actually apply violence, it's still an assault, isn't it?
I think assault is somewhat different because assault can also be an attempted battery. But it's my understanding there is law to the question that assault, when it involved placing someone in fear, did require a specific intent.
How does one prove what's in somebody else's mind. This case, the standard was, would a reasonable person think that the words would put someone in fear? And reasonable people can make that judgment. But how would the government prove whether this threat in the mind of the threatener was genuine?
I think two ways, and generally speaking. As we indicated in our brief, in order to prove up these threats, which are increasingly made online using a cell phone or a computer, you will have to search the computer or cell phone to show that it was actually used to make these statements. You will also find on there a wealth of information, as the Court indicated in Riley. People conduct their entire lives electronically.
Yeah, you're going to find a lot of information on the cell phone ever that the guy is really angry at his ex-wife. Would like to see her suffer, and he's going to put it online, and then you're going to say, well, that was just therapeutic, as you said in your brief. It was therapeutic. Yes, of course, it shows that he was going to do something dangerous. It's a good thing that he had this outlet of the Internet, so he didn't have to do it.
But I think that the point is that there's a lot of information you could find. You could find, for example, that he had visited a web page where she confided to someone else that she was in fear. You can find it. You could prove. You could find
the fact that I thought your whole point was the fact that she's in fear doesn't tell you enough about what the defendant wants.
No, but if you can see that he visited her website at a time that she was saying, "I'm afraid of this guy," or "I'm afraid of what he's saying," you could prove up that he knew at the time that he was aware.
Based on your submission, all he has to do is say either, as I understood your brief, it's therapeutic, it's a good thing I could do this, or it's art.
If he is on notice that she is in fear, that is all we're asking for, that if he knows that she is in fear, he doesn't have a right to continue on. That is what we view as stating an intent to cause fear. If you are aware of it.
Could you tell me whether it's your – I'm sorry. Could you tell me, and I'm coming a little bit –
Do you guys think Sniper Wolf had an intent to cause fear?
Ginsburg's question. You can infer what a person's state of mind is from the circumstances of how and what was said in words, correct?
That is correct.
So if that's the case, isn't the jury acting like a reasonable person in looking at the words and the circumstances and saying, did he intend this or didn't he? I mean, I don't know what the difference between the standard given and the instruction you want.
As the government put it in this case, in the closing argument, under the instruction that was given, it doesn't matter what the defendant thinks. What matters is whether a reasonable person would foresee that the listener would be placed in fear. And so it is essentially...
But, I mean, how is that different from what you intend? If you know, if a reasonable person is going to read this word this way, aren't they going to assume that's what the defendant intended?
But it's a negligent standard. It holds him to a reasonable person's standard, regardless of whether he actually was aware of that. It holds him to what a reasonable person would have.
Yeah, this goes on for an hour.
Sort of along the same lines, and getting back to what the Chief Justice asked you, because I was a little bit surprised by your answer. I'm trying to figure out what exactly the level of intent you want is. So the very, very highest level might be, I affirmatively want to place this person in fear.
That's the highest level.
I'm doing what I'm doing. All right? There's a step down from that, which is, I don't want to do that. I'm just fulfilling my artistic fantasies, whatever you want to call it. But I know that I am going to place this person in fear. All right? Is that which intent do you want?
The second.
The second.
That if you know that you're placing someone in fear by what you're doing, that is enough to satisfy our version of.
And how about just take it a step down more, but not get to the government's? How about if you don't know to a certainty, but you know that there's a substantial probability that you'll place that person in fear, which is what I take it we usually mean when we talk about recklessness.
I think that we would say recklessness is not enough. The court said in U.S. Gypsum that recklessness and negligence were not enough of a mens rea even for antitrust liability, and so we'd say the same would apply here. Traditionally, courts have applied, and in Global Tech, this court said that willful blindness satisfies knowledge. But the willful blindness test spelled out in Global Tech was beyond recklessness, and it took an extra step to try to distinguish it from recklessness.
Well, what would be wrong with the recklessness standard? Why is that too low? It seems that the recklessness standard has a kind of buffer zone around it. It gets you.
This is where V and many of the razor fist types are. They're with the recklessness stand. She recklessly posted a picture of his house. Something bad could happen. She's got 34 million subs. Surely one of them's a psychopath who wants to simp for her. That's dumb. That's the same logic judges use when they want to silence Trump with his 100 million followers. Surely one of them will do something crazy.
You up one level from what the government wants. So who's the person that we should be worried is going to be convicted under a recklessness standard?
I think many of the speakers who are online and many of the people who are being prosecuted now are teenagers who are essentially shooting up their mouths or making sort of ill-timed, sarcastic comments, which wind up getting them thrown in jail. For example, there is pending now a case involving a couple of Texas teenagers who were in a video game chat room.
Gamers!
One called the other one crazy, apparently for something that he said about a video game. And the other one responded, "Yeah, I'm crazy. I'm going to shoot up a kindergarten and eat when they're still beating hearts." Neither of them seemed to think that they understood that as sarcasm, but as it happens, there was a woman in Canada who was watching. She reported them to the authorities. He was arrested. He was held for 4.5 months before he was eventually bonded out, and he is still facing trial. Happily, Texas is one of the many states with a subjective intent requirement, so there's a good chance he'll be acquitted.
Bro, his joke went so hard he spent 4 months in jail. He talks some mad shit on Xbox chat, man. I want to play with that guy.
I would not want to bet a felony conviction that would not be covered.
I bet you they loved him in jail.
Reasonable person, at least as I understand the government's submission, it's a reasonable person familiar with the context of the statement. Right? So you don't take what's on the Internet in the abstract and say this person wants to do something horrible.
Okay, this guy's actually the guy we're listening to, John P. Elwood. He's representing the defense. So I want to hear actually the government. I want to hear the anti-free speech government.
That's right.
Communication.
Oh my God, this guy's voice.
The mens rea component.
Any sort of speech that uses, forceful language or violent rhetoric when walking into a family planning clinic.
Query, I assume.
Thank you.
Thank you, Mr. Chief Justice, and may it please the Court.
Sounds like
V. This Court has made clear that true threats, which may not be the best term in the world to describe them, but it is getting at an important point, cause fear and disruption to society and to the individuals who are targeted. And for that reason, Congress enacted a statute that depends upon a mens rea component and an actus reus component. The mens rea component is that the individual has to know and understand what the individual is saying. Congress reasonably presumed that people who are speakers of the English language and who know that the words what the meaning of the words is that they speak are accountable for the consequences of those words.
And the minimum penalty is what? A fine, right?
That is correct. There's a minimum penalty. There's no mandatory minimum prison sentence here. The important point
But it is a felony.
Yes, it is a felony, and I think that Congress was quite clear that when it enacted this, it did not prescribe any additional specific intent or purpose to frighten or to threaten that Petitioner, up until standing at the podium today, appeared to argue for. Petitioner's position until today was that it's not a threat if somebody can say, hey, didn't really mean it, sorry, that wasn't my purpose or intent, I knew that the words that I was speaking had the language in them that they did, I can take it that a reasonable person would have interpreted them that way. Petitioner would even cut out recklessness, even if the speaker was consciously aware that it was likely to cause fear. Petitioner would say.
Can you go back? That's exactly the point that's bothering me. I'm with you down to forget the purpose. I'm with you. There has to be a true threat. We'll assume that. And now the question is knowledge. And that's the general requirement for mens rea where there's just a general. That's the normal rule, knowledge. And you have to know those portions that make up an actus reus. You have to know the elements. One of the elements is a true threat. So I thought, what do you say you have to know there? And when I read your brief, you first said he has to know, he has to understand the meaning of the words he speaks in context and must intentionally speak them, and is showing that the defendant acted knowingly in transmitting a true threat requires proof the defendant knew he transmitted a communication and he comprehended its context and context. Now, when I first
context
read that,
and context.
You hear my clerks have disagreed with me. I thought, well, that means he has to know that it is a true threat, i.e. that a reason. Why did I think that?
So
we just saw people being sworn in. Suppose someone comes from, I don't know, and he hears them say, I do, I promise. Does he know the meaning of the words? Unless he knows the action. So a marriage is better. Someone who's never seen marriages hears the bride say, I do. Has the person understood the meaning in context of those words? If he doesn't know that that means they're married and go through a lot of legal proceeding? And similarly, can a person know the meaning in context of true threat unless he understands, just like the words I do, what a true threat is?
The individual can know the meaning of the words without necessarily drawing the same conclusion that the recipient of the communication or a reasonable person would. That is, I think,
quarreling with Justice Breyer. Obviously you are.
Yes.
Why are you quarreling?
This is the whole.
It's not enough for us to say a true threat is when you intend to put another person
in fear,
or you know that your words will cause a reasonable person.
He just mansplained her. He just mansplained a Supreme Court justice. Let her speak. She's a strong, independent woman. She doesn't need help. This fucking white knight right here. This is what the feminists rage about. She's a Supreme Court justice. She can finish her sentences herself. I'm sorry, we just saw live action mansplaining in the Supreme Court.
You're quarreling with that formulation.
That's right.
You want something broader.
What we want is a standard that holds accountable people for the ordinary and natural meaning of the words that they say in context.
Well, but in context is right. What is it? Is it a reasonable person, and the examples that were given of the teenagers on the Internet, or is it a reasonable teenager on the Internet?
If there is such a thing. Sorry, Mr. Chief Justice. The context that was used under the jury instruction in this case, and I think that
that's almost kind of like the court kind of realized there the laughter. A reasonable teenager on the Internet, if there is such a thing.
Appropriate one. It's more protective of the defendant, perhaps, than a reasonable listener approach, is a reasonable speaker approach. Whether he would foresee that a person to whom the communication is addressed would interpret it.
They're going to say the phrase again.
So but there again, we're talking about what subculture you're looking at. I mean, is the Internet exchange, is it what the reasonable teenager thinks, how it would be understood by the recipient of the text?
The speaker chooses their audience. I mean, the speaker can communicate in a completely private manner. On a Facebook page, the speaker can make certain aspects of the communication private, or the speaker can open it up more widely. I don't think this case requires the court to decide the full dimensions to what the context is, because here it was quite clear what the context and the...
Well, I know, but you're asking for a standard that presumably would apply across the board. So if the teenager has a lot of friends on his Facebook page, then you're going to evaluate it by a different standard?
If SS Sniper Wolf has 34 million subs, are you going to evaluate it by a different standard, V? Man, these Supreme Court cases, it's almost like, it's almost like they thought about these things before.
friends all over different age groups and everything else. That's a different standard than if he has only a few friends that have access to his statements?
It will depend on to whom he's communicating the statement. We all know that if we're communicating among friends, particularly in face-to-face context, we can say certain things that will be understood as sarcasm. But when we widen the audience and put a statement out in a situation where reasonable people are going to react to it by saying, this requires attention. This is a threat against an elementary school.
But that it doesn't seem to me answers Justice Scalia's hypothetical of the friend who calls to report the threat, or another hypothetical. One student says, I have a bomb in my lunch pail, and the other student hears it and tells the principal. Under your view, the person who hears it and tells the principal could be liable.
No, that's not our view, and I think it's important to clarify.
But what is the suggested instruction you would have in order to eliminate liability in my hypothetical, or Justice Scalia's hypothetical is the same thing of the friend?
The statement has to express a serious intention of the speaker to inflict bodily harm on somebody.
That was not in the instruction that was given in this case.
Not literally, and it wasn't requested, and I think that it is implicit.
Well, I mean, if you're saying it's waived, that's something else. But the instruction given by the district court in this case does not meet the standard you just gave.
Well, Justice Kennedy, I think that it does if you read it in entire context, that it was understood as being a reference to the speaker's intent to carry out the threat. So, and we're not asking.
It seems to me that if that's the case, you should have no problem at all in accepting Mr. Elwood's suggested instruction, a specific intent.
No,
or
because
has specific intent, as you well know, all the time.
Let me give you a couple examples of what Mr. Elwood's position, as I understand it, would cut out. It would certainly cut out people who are reckless, people who are consciously aware that this would be taken as a serious expression of an intent to do harm, and the speaker says, I'm going to disregard that and say it anyway.
Well, how about using that exact standard? And it's pretty similar to the standard that Justice Breyer had, because the way Justice Breyer had it, it's knowledge that a reasonable person would cause fear. You could say it's basically the same thing to say, substantial probability that the person you're talking to would feel fear. So either way, there's a little bit of a fudge factor but the critical point is that you have to know something about the probability that you're going to cause fear in another person. And if you really don't know that thing, then you're not liable. What would be wrong with that?
Well, the first thing that's wrong with it is that it basically immunizes somebody who makes that statement and then can plausibly say later, hey, I was dead drunk. I realized that I just called in a bomb threat, and the police had to respond, and an elementary school had to be evacuated.
No. For some weird stage, we have ruled that being a drunk driver, driving drunk, doesn't negate you of all the liability from doing what damage you caused for driving drunk. So you still have to do you still have to pay for your actions when you're drunk. So no, nice try.
Drunk, it really didn't.
Drunkenness is often not a defense in a specific intent case.
Yeah,
drunkenness
jackass.
is a defense in a specific intent case.
With knowledge. I mean, I want Justice Kagan, and I would just try to get you to focus very specifically, I think, on forget the First Amendment issue here. Take it to the side. Forget it. Let's look at ordinary Hornbook criminal law after the Model Penal Code. There, the normal, as you say in your brief, requirement is that the person know the elements of the offense. That's normal. If it is drugs, he has to know that this is a drug. If it is threat of force, he has to know that he has a threat of force, I take it, or that it's a bank. So why shouldn't he here have to know what is an element of the crime, namely that there is a true threat as so defined?
So
just Hornbook criminal law, are we departing from it or not?
Yeah, actually, your description of the bank robbery situation is illustrative, because if you just look at the statute that this Court is going to consider tomorrow, 2113, which was interpreted in Carter, to require knowledge that you're engaging in the conduct. No intent element, no specific intent element. So if somebody
I agree with you, no specific intent. That is, you don't have to have it to be your purpose. That's why I use the model penal code terminology, which for me is easier. You don't have to have it as your purpose, but you do have to know the elements of the offense.
You just have to know what you're doing. You just have to know what you are doing. You do not have to know that.
All right, you have to know what you're doing. What you are doing is you have to communicate a true threat.
And Petitioner is not disputing in this case that he knew the words that he was saying. We're not disputing that the government has to show that the individual is aware of the words that they're speaking. The dispute here is over whether the government has to show that the petitioner actually intended to cause fear, or today Mr. Elwood has proposed moving down a level to knowledge. Justice Kagan has proposed moving down one level further to recklessness. My submission is that when Congress passed this statute, it intended to capture all of those people by making no intent element in the statute beyond the knowledge of what the speaker is saying. And the presumption is that when you speak English words and you're an English speaker, you're accountable for the consequences.
So the drunken
wow, this guy is a words have consequences lawyer. Michael DeBreen here is literally words have consequences. Amazing. That's his stance. Words must have consequences.
I don't know what I was saying. Is he or she guilty?
Yes. The drunken person who creates panic and a disruption and would be reasonably interpreted as having uttered a threat under the government's view is guilty. Under Mr. Elwood's position in his brief, that individual would not be, because involuntary intoxication can negate specific intent. It's Hornbook law that is a defense. Under the position that he's argued at the podium today, perhaps not, because voluntary intoxication doesn't necessarily negate knowledge.
I'm still not sure how you answered Justice Scalia's hypothetical and mine.
Let me try one more time.
The threat is just repeated.
That's right. The person who repeats
with no bad
the threat
purpose.
Let's say a newspaper prints it on the front page. The newspaper is not expressing its intent to or making a statement that reflects the speaker's intent to inflict harm. What the threat is a statement that the speaker makes, which on its face and in context would be understood as an intent to inflict harm. Repeating it doesn't have that characteristic. And I think we discussed, Justice Kennedy, that the jury instructions don't say that literally, but I think in context that's exactly how they were understood.
If you have a statement made in the style of rap music, as this one or several of these were, is the reasonable person supposed to be someone familiar with that style and the use of what might be viewed as threatening words in connection with that music, or not?
So, Mr. Chief Justice, it depends on whom the speaker is speaking to. If the person is speaking to
a general
audience, then I think that the individual has to understand that not everybody will have the same private meanings that person attaches to rap music and will bring.
Oh, boy.
So that does subject the prosecution, the lyrics that a lot of rap artists use.
No, not at all, Mr. Chief Justice, because in the context of those statements, it's pretty clear that the purpose of the communication is entertainment. People seek out rap artists because they are seeking some form of entertainment, and that is a
So how do you start out if you want to be a rap artist? Your first communication, you can't say, I'm an artist, right?
I think that you have perfect freedom to engage in rap artistry. What you don't have
rap artistry
to do is to make statements that are like the ones in this case, where after the individual receives a protection from abuse order from a court, which was based on Facebook posts that his wife took as threatening, he comes out with a post and says, fold up that PFA and put it in your pocket. Will it stop a bullet? He knows that his wife is reading these posts. He knows that his posts, despite the fact that they're in the guise of rap music, have instilled fear in her. And he goes out and he ramps up and escalates the threatening character of the statements. This is completely different.
You've just made a wonderful closing statement. But a summation. But why is the instruction that, or any of the formulations suggested here, going to harm that?
So I think, Justice Sotomayor, the clearest problem would be if the Court goes with the position that Petitioner advocated in this case, which is that there must be a purpose to frighten, because that would exclude the person who's conscious, yeah, I know that this would probably scare my wife, but so what? It cuts out recklessness. It cuts out voluntary.
I think Mr. Elwood disavowed that. He said he has to know that she will be in fear.
Justice Ginsburg, he did disavow it, but the time to propose a jury instruction is in the district court, not from the podium as the petitioner is arguing the case in the Supreme Court. Now, I agree that this Court should decide what the statute means and is properly
Yeah, but he didn't have good representation at the time, I bet.
Requires. But there was no request for a
That was a little underhandedness right there.
No argument that the proper standard is knowledge, let alone recklessness.
My understanding of the model penal code levels of mens rea is that there is a distinction, but a razor-thin distinction between purpose and knowledge. So the idea that backing off from purpose to knowledge is going to make very much practical difference, I think, is fanciful. There's a considerable difference between knowledge and recklessness. Would you agree with that, or do I not understand that correctly?
I think you basically understand it correctly. I think I would attribute a little bit more distinction. Purpose is the conscious intent to achieve the very goal. Knowledge under the model penal code is acting intentionally with knowledge to a practical certainty that the result will follow. And then recklessness takes it down to you're actually, aware of the risk and you're indifferent to it. You act grossly negligently. It doesn't have to be to the level of knowledge. It's just that there's a significant risk and you disregard it. So there is a jump.
Exactly. I think that is the distinction. I'm thinking that perhaps a lot of these cases would come up in domestic relations disputes. And in such a case, the question would be, because people get into heated arguments, do you have to show the defendant used some words that
Let's go back to some different cases. I'm curious. We need some more free speech cases around here. Where's Brandenburg? I don't want to hear Brandenburg. Wow.
492, Clarence Brandenburg,
The Warren Court.
versus Ohio.
Look at these guys. Bunch of straight white males. It's on a record, man.
Mr. Brown.
Mr. Chief Justice, members of the court, we have before us a case arising in the state of Ohio under a conviction under Ohio's Criminal Syndicalism Act. We have indeed before us something of a rarity. It is, as far as I know, the third case ever tried under Ohio's Criminal Syndicalism Act, and the first to ever reach an appellate level. There was earlier in Ohio, under peculiar proceedings, in which a prosecutor could bring a proceeding before the Supreme Court on appeal for a question of law only. A proceeding in which a motion was made in the lower court in Ohio attacking the constitutionality of Ohio's criminal syndicalism law. The lower court in Ohio held the law to be unconstitutional. It was appealed to the Supreme Court in State versus CashAPP, and in what is basically an advisory opinion, the court stated that it was constitutional. The court also stated several engaging other things. It stated that the First Amendment did not apply to the states of the Union. It also stated that the measure of its application was an issue in its constitutionality, and that it would attend the first trial of a case to see what is the proper measure of its application. The court waited patiently for the first application to a case, and it arose some 40 years later in this case And surprisingly, despite the invitation sent out in Cassay, the court declined to even hear a constitutional question on the application in this case. It, in fact, defaulted to this court Ohio's privilege of setting forth the limitations of the application of its statute, and Ohio's privilege of setting forth the potentiality of clarification of a statute which obviously on its face rushes headlong into the First Amendment. These are the facts in this case. A television reporter received a telephone call indicating that if he wanted to, he could come and take movies of a Ku Klux Klan meeting. He came. He met some hooded figures, and arrangements were made for the taking of a movie.
Hooded figures.
A movie was taken in which a cross was burned. Some figures
I gotta write a joke about that somewhere, about how, yeah, I'm scared of hooded figures. Black people are too. Something like, we'll work on that.
Out and yelled some stupid and rather senseless slogans, and then a single figure was panned in on who made a speech full of conditions,
hooded figures,
and reservations, and hyperbola, self-evidently stupid and silly. He asserted that the Klan was the largest organization in the state of Ohio. He then went on with a conditioned precedent that if the various branches of the government, including this court, do not mend their ways, that revengeance, a word of his own coining, I assume, would be taken. He did not specify the revengeance, and we do not know what particular aspect of the democratic process he was going to involve himself in revengeance. He then spoke of a march, not in identifying it as an armed march or any sort of march of any force or violence, into
just like Trump,
and then into two southern states, incidentally raising federal questions, perhaps rather than internal state questions. Another film taken is inside a house.
There were guns. There were guns in this first.
There were guns in both films.
In both of them.
In both films, there were guns. It is also to be noted that the film was taken on a remote, private farm, in which apparently there is no evidence whatsoever that these people were not invitees present on that farm by authority of the ownership of the farm. There was nothing adduced. An indictment was returned after some preliminary maneuvering, including a frontal attack upon the constitutionality of the statute. The case came on to trial. The state produced nothing but the film in question. The only other evidence that the state produced was basically geared to identifying the personnel involved in the film. In other words, showing that the man Brandenburg had a gun similar to the guns in the film, and that he had markings on his person similar to the markings, and that his voice was similar. Other than this, the state offered nothing. It is critical that the state offered nothing on the nature and history of the Klan. It offered nothing showing the course of the Klan's history, any continuing historical or expert opinions concerning any possible commitment to violence. It offered nothing on the continuing organization of the Klan, nothing whatsoever.
This is the ADL speaking, I think.
Other than the film itself and the words
not the ADL.
In the film itself. The state
The
then
free speech one.
The defense, in which I was not involved, I am a point of counsel appointed for purposes of appeal, made a motion for dismissal at that time. I will frankly admit that the motion for dismissal, which was made by then counsel, was simply a weight of evidence motion, and he did not specifically denote the constitutional question that had arisen at that point in the presentation of the state's case. I suggest that it is completely immaterial that he did not. The defense then proceeded forward and offered basically a defense of depositive testimony in which various officers of the Klan testified as to their ostensible peaceful purposes and things of this sort, and the historical evaluations of the presence of weapons and the burning of a cross. The court then charged the jury. The court's charge to the jury, and I specifically asked this court to consider it carefully, begins in the appendix at page 72, and met with a statute that thrusts itself clearly within the First Amendment, makes on its face no attempt to give us an indication of a line of demarcation between the mere abstract teaching and advocacy, or even advocacy in relation to a clear and present danger as to advocacy in a hypothetical sense. That in no way on its face does this. The court perpetuated the evil of the statute by making the charge even more general, in which he indeed defined the term advocacy as involving intrinsic in it, in his own charge, teaching. So that we had, at this point, a man who had been tried with none of the safeguards of the First Amendment applied to the trial of his cause, to the measure of his evidence, or to the instructions to those who were to be the triers of the fact, which would demarcate a point at which the First Amendment would be operative in relation to what happened on that isolated farm on that isolated day.
It's really great. How large was this meeting?
The pictures, the testimony, and the pictures indicate that perhaps 20 persons were involved.
Any spectators?
No spectators. All were participants in the meeting. There is some indication of the record that there were no women folk in the picture.
Women folk!
There's some testimony in the record that one of the TV reporters said he heard women's voices in another room. I know nothing else about the women folk on that occasion.
Women folk!
Pardon, Your Honor? The film is an exhibit. I pray it is. I have ordered it, and my last word from the clerk was that they were having trouble finding it, but that they would find it and send it on up here. I devoutly pray, because we do have in this case some issues as to what are shown in the film. And
is there a dispute between the parties here as to whether there was or was not a call to engage in violence?
Yes.
There is a dispute.
There is a distinct dispute. It is our contention that there was nothing in the speech, which is part of the record, and as shown in the film, and since the state limited itself to this, there is nothing in it that is a call to violence.
And your adversary disputes that?
I assume my adversary disputes that.
The state's whole case was the film plus the identification of the defendant as the person shown in the film. Is that right?
The language of the film is actually in both parties' briefs. The difference between us is that they tend to ascribe certain slogans by the persons milling about to the given defendant. We contend that the only words that the given defendant uttered were the formal set speeches.
This film was shown over a local television station.
This film
and
was
over a
shown
network, wasn't it?
over a local television station and a network.
And a network.
That's correct.
Who was the trial judge?
It's Judge Simon Lease. Does it ring any bells, Judge?
Yes, it does.
Okay.
Mr. Brown, I gather the indictment, however, was for the events. Is that right? Was the events depicted in the film, not for the exhibition of the film, was it?
That is correct.
In other words, all the film was in evidence was depicting what happened on a certain day.
That is correct.
And it's because of what happened, it was alleged there had been a violation of the statute.
That's correct. The act of showing it over television, which incidentally had intervening parties, the authorities running the television station, are not the basis of the indictment and the charge.
So that I gather, if we're to read the record of the case, we have to see the film, don't we? To know what the proofs were that...
Precisely. As a matter of fact, in the Supreme Court of Ohio, we didn't raise it here because we wanted to see if we could make sure we could get cert. We asserted that the film was in the same position as a book in an obscenity case.
Oh, that doesn't help you.
I know it doesn't help us now, but at that point when we were before the Supreme Court of Ohio, we asserted that, saying that the film in and of itself is the entire context of the alleged offense.
I don't understand your point that nobody but the audience was being, members of the group were being addressed. I don't see the relevance. The reason I ask that is that in the Dennis case, Dennis versus United States, involving the prosecution of communist teachers,
Based?
the Marxist creed.
Based?
Nobody was exposed except the students in the classroom.
May it please the court, there is this important distinction to be made between the Dennis case and that case. In the Dennis case, the teachers who taught these classes, this was evidence within a total context.
We're going to watch that one next.
Conspiratorial activity leading to a total action result. In this instance, the state contented itself merely with showing a given speech and did not choose to present any evidence to make it part of a conspiratorial whole. It took the speech in and of itself and presented only that.
That's why I asked you earlier. The indictment was for the events depicted.
That is correct.
Not for the showing of the motion picture or in the context of conspiracy or anything else.
That's correct.
It's just what happened on that
What
particular
happened
day.
on that farm on that day. And that is the important distinction to be made.
Did this appellant have anything to do with arranging for the events to be televised?
There is evidence in the record that indicates that his was the voice that called the radio TV announcement.
Well, if that is so, then it's it's debatable whether this was addressed only to the people who were physically there.
That may be the case, Justice Fortas. But however, the state of Ohio chose not to charge him for that.
If he had arranged for it to be televised, presumably he intended that his remarks reach a larger audience.
It is quite potentially possible. This is, however, not what the state chose to charge him on. Read the indictment. And
if the court could take judicial notice that the Communist Party was conspiratorial out to conquer the world, why couldn't the court take notice that the Klan was up to no good?
In the Dennis case, I submit that the court did not take such judicial notice. That in the Dennis case, as a matter of fact, there was the adduction of evidence to show that.
I think you may be taking some liberties, counsel, with the record in the Dennis case.
In any event, it is clear that in the Dennis case, there was additional evidence over and above that adduced in this case.
Adduced.
In this case, they showed nothing but the film itself. They showed no
that adduce in this case.
Other than
so as far as you ask us to deal with this case as if it was just a group of schoolboys, hooded schoolboys,
that is evidence.
Sitting in a room listening to...
That is a potential distinction between this case and the Dennis case as well. These are paltry unknowns, rather silly characters. In the Dennis case, we're dealing with the established leadership of a national organization. This does make a difference in relation to the rights prevailing under the First Amendment. But in this given case, there are other distinctions, which I'll pass to in a moment.
Notice how they're not asking questions, letting this guy talk.
With a statute.
It really changed the way they do this in the past 50 years.
Thrusts itself into the First Amendment. We are dealing in this situation not with an address to an evil from which we must move back to a possible restraint upon First Amendment. For we are dealing with an entry particularly into the right and then a prescription upon the right as it might engender an evil. For instance, it denotes First Amendment.
Well, I gather, Mr. Brown, that apart from your argument addressed to the statute...
Byron White.
Divorced from the...
He's like one of the most recent ones.
You do argue, don't you, that the First Amendment considerations are so close to the surface in a prosecution under such a statute that at the very least it required an instruction which was not given here.
That is correct.
Was recognized, though. And if we agree with you on that score, I gather.
I want to look up Dennis. Oh, excuse me. Dennis. What is this? All right. I think that's our little free speech primer for right now. V's been completely blasted and destroyed, and he'll never recover. Did she express her intent to cause fear? No. Then you can't charge her with threatening. You can't charge her with doxing. Sorry. Get fucked. Radically Moderate out of here.